minutes or 25 minutes if possible.
Sure. So Isha, should I start, or are there some introductions you need to do?
Sir, I think Tawasha would go ahead with the introductions in this regard.
So good morning, everyone, and thank you all for joining us here today. I welcome all of you to today's first session, which is on the topic towards a robust legal regime in India to promote cross-border trade. During the session, we will discuss various legal regimes and instruments that aid progressive development. For example, we shall be discussing the UNCITRAL model law on secured transactions, which seeks to reform and modernize the international law applicable to secured transactions. In the Indian context, this session would deal with issues in the interpretation and application of this model law to the trade receivables discounting system introduced by the RBI. During the session, light shall also be thrown by our speakers on the recent Singapore Convention on Mediation. Before we begin, I would like to take this opportunity to introduce the panelists we have with us today. We have with us Mr. Anil Kumar Rai, who is the professor at National Law University, Delhi. He specializes in banking and corporate law, insurance law, and telecommunication laws. We also have with us Mr. Shreyas Jayasima, who is the founding partner of Arna Law, a boutique counsel-led international and domestic dispute resolution practice. He is an advocate, arbitrator, and mediator with over 20 years of experience in domestic and international dispute resolution across various industrial sectors. Our third speaker is Dr. Risham Garg, who is an associate professor of law at NLU Delhi and director of the Center for Transnational Commercial Law. He specializes in the areas of transnational commercial law and insolvency and bankruptcy law. Thank you all for joining us today. This session will be moderated by Mr. Apurv Mishra, who is the editor-in-chief of India Law Journal and a senior research fellow at India Foundation. I now invite him to begin the session with his introductory remarks.
Thanks, Tawasha, and thanks, Isha, for bringing all of us together. We are here to discuss issues relating to international trade at a very interesting moment. As you know, the world is going through a very, very challenging pandemic. All countries are, reinvestigating and reimagining their economic models, especially their engagement with international trade. As this is happening, the recent Ease of Doing Business Index rankings have come out, where India has again jumped several places and become 63rd, which is a far cry from the measly 142nd rank that we had 5-6 years back. So while we are going through a pandemic and some very, very difficult times economically, the Ease of Doing Business index in India has we've done quite well on that index over the last few years. We are also 1 month away from a budget which the finance minister has promised will be once in a century budget. So in the middle of very interesting times, we are having this conversation on the requirement of a robust legal regime for international trade. Just before I invite Mr. Jayasima to speak and share his views on the Singapore Convention on Mediation, let me just say that while we've done very well on the Ease of Doing Business Index of the World Bank for the last 5 years, there are 10 parameters on which they measure the Ease of Doing Business Index in the country. And one of them is solving legal disputes, solving contractual disputes, where consistently we've performed very poorly over the last few years. And the government has been, trying very hard to improve its ranking on this specific parameter. While on some of the other parameters, we've done quite well, like starting of a business, closing of a business, etc. On resolving commercial disputes, we are still performing very poorly on the Ease of Doing Business Index. And therefore, you've seen over the last few years several attempts by the government to improve the ease of doing, ease of solving commercial disputes in the country. So whether it is the passing of the Commercial Courts Act, whether amendments to the Arbitration and Conciliation Act, signing the UN Convention on international settlement of disputes, and then being a founders member of the Singapore Convention on Mediation. These are all attempts by the government to showcase that India will adhere to international standards as far as commercial dispute resolution is concerned. And so with those introductory remarks, may I invite Mr. Jayasima to please give his address. Sir, if you could speak for about 15 to 20 minutes, then we can then have a Q&A based on your remarks after your initial comments. Mr. Jaisima, over to you.
Namaste to all attendees, and thank you, Dr. Garg, for this kind invitation, and friends, colleagues, and Mr. Mishra, our moderator for today. Thank you. I was there when the Singapore Mediation Convention was signed in Singapore, and it was a most extraordinary event to observe. In the midst of tensions in different parts of the world, can you imagine that there is still space for peace and calm and discursive space for intellectual dialogue when countries with diverse national interests, such as Israel, Iran, United States, Afghanistan, a whole bunch of countries signing, and I think the entire count that day was about 47 or 48 countries, which is far more than the first day on which the New York Convention was signed in 1958. And we know now that the New York Convention is perhaps the most widely accepted international instrument that the UN system has produced. It's very possible that the Singapore Convention or the international settlement agreements resulting from mediation might also have that reach in due course. What is it about this concept that has motivated 47 or nearly 50 countries to sign on the very first day? There was a disruption in the internet. Can you hear me? Mr. Mishra, can you hear me?
Yes. Yeah,
okay.
We can.
Okay, there was some disruption here. It is, as I said, really a momentous occasion that parties and countries recognize that in the array of dispute resolution options that parties have, apart from litigation, arbitration, even forms of conciliation that might exist, there is a further space and a very important space for mediation. Of course, within India, we already have many statutes which contemplate either forms of conciliation, be it in the industrial sector or the commercial sector, like the Arbitration Conciliation Act, or indeed specific reference to mediation. Most significantly now in the Commercial Courts Act, where there is a necessity to have a pre-institution mediation of disputes. In that sense, even before formally signing on to the Singapore Convention, India has embraced very warmly and strongly the idea of encouraging parties to look to amicably resolve disputes rather than to continue to burden either courts or arbitral tribunals and increase their own time and cost. I was joking with colleagues in Singapore that it ought to have been the land of Buddha and the land of Gandhi and the land of Ahimsa that ought to have lent its name to the Mediation Convention. But it is what it is, and we will all have to still refer to it as the Singapore Convention. But these ideas that I earlier mentioned of non-violence, non-violent communication, non-violent dispute settlement are uniquely Eastern concepts that we can contribute to very richly based on our own heritage and history of ideas. And here, please bear in mind, and I think in the first session also it would have been mentioned, that India has been one of the founding members of UNCITRAL. And at the same time, India's voice in UNCITRAL has been striking because, unfortunately, of its silence. It is now left to all of us to give voice to thoughts and ideas and contribute to more robustly to the evolution of such instruments going forward, not just in mediation, but in every other instrument of private or public international law reform. The opportunity is there, therefore, for us to not only understand contemporary conventions, ideas, and comparative legislation, but I always believe strongly that the deeper we are rooted, the further we can fly. It doesn't matter, and we have such a rich and multicultural heritage of ideas, contemplating techniques of attaining peace internally and externally. It is said, on the Gandhi Jayanti this last time, I had the occasion to listen to a speaker who said so humbly and eloquently that how is it that lawyers and professionals can so arrogantly claim to resolve conflicts externally, when deeply and fundamentally at a human level, most of us, if not all of us, are highly conflicted beings. If there is a lack of synchronization between this lack of internal calm, a lack of internal integration, and then trying to implement it in a compartmentalized fashion in a particular, be it a contractual issue or any other, would be an incomplete exercise. And deep thinkers, many of whom who happen to be lawyers, from Mandela to Gandhi, Lincoln even, have always identified that the nobler path of those with legal training is to recognize with humility that the source of conflicts is very deeply internal. It can be externalized by description. But if that external conflict is scrutinized intensely, almost always it can be traced to matters that have to be resolved internally as well. Mediation, therefore, gives voice to the commercial world, if not to lead a fully integrated life, to lead a more integrated life. For parties in dispute, let's say in commercial disputes, there is no need to merely because a particular difference has arisen to burn the bridge of the relationship that exists between the parties that had brought the parties together in the first place. The cost, therefore, the opportunity cost of a dispute which is not resolved amicably is extremely high, because the best that a party can get out of an adversarial system is perhaps the money equivalent of some experience of the past, a breach or some other cause of action that has occurred in a previous moment in time and space. What about the present? And what about the time that has been spent during the resolution of such an adversarial dispute? And what about the future? Adversarial dispute resolution processes, in that sense, are dealing with bygone times. And it is very easy to slip into a cynical, over-intellectual approach to saying, these are very finely balanced issues of fact and law that require a lot of time, money, and effort to be spent. But in that very process, there is a continuing opportunity cost that is being incurred. And that opportunity cost is not merely economic, it is social, it is cultural, and it is an all-round cost that is being incurred by a lack of appreciation of more robust forms of amicable settlement. So I have always believed, and my practice as a mediation advocate, in addition to my role as an arbitrator advocate and a litigator, I have felt that of these three, enough can never be said in praise of mediation. Enough can never be said to a party to open their eyes to consider the process at any stage of the dispute. We should not relapse into a tick-the-box approach to say, no, it says pre-litigation dispute, pre-institution mediation, and therefore we will only think of it before the dispute. The contractual clause might also have a tiered clause, which says that mediation is to be considered or negotiation before getting into either arbitration or litigation. Again, the spirit of that imperative is to remind parties to consider that process of resolution throughout their present and future, not merely before sending out a notice or an email initiating an arbitration or a litigation. That may be the letter of it, but it is not the spirit of it. And ultimately, any document is to be worked by human beings. If the counsel, if the neutrals associated with a contract, which only in letter refers to, let's say, mediation or amicable solution, these individuals are not barred from elevating their own consciousness, from awakening the noblest instincts possible, both within and then to be able to inspire it in the other. And it takes an act of courage, not an act of weakness, to take the first step, to pick up the phone, suggest the idea of a amicable resolution, or suggest even mediation, even if the contractual clause does not contemplate it. One of my earlier colleagues was very nervously asking me to say, sir, you're talking so much about settlement. What's going to happen to our office? What will happen if there are no files? So I had to say, that would be the most ideal state of a lawyer's office. To be briefless is an aspiration. It's an ambition. It's a mission statement. It's not a nightmare. It's not a source of fear. Imagine a world. John Lennon can sing about it. A world without lawyers, with such great contentment that you don't need to clutter lawyers' offices with briefs. This irrational fear of mediation or of settlement must be called out wherever it is found. It may be found in the mind of a party. It may be found in the mind of a lawyer colleague. Gently but firmly, such an irrational paranoia of rapprochement identified, diagnosed, and healed. There is still space in the real life for a Munna Bhai or a equivalent, in the law approach, because this, as Oliver Wendell Holmes constantly reminds us, the life of the law is an experience, not in logic. And the best lessons of our lives were perhaps not taught in school or in college, but in the laps of our grandparents. And any one of them would encourage us to remember it's as we grow into positions of power, positions of formality, that these early lessons become most important. And it is then that we are most vulnerable to forgetting them. It's in this context that I'm very proud as an Asian that, at least if not India, another Asian country has lent its name to the Mediation Convention. The convention itself recalls the fact that they had resolved to look at the idea of coming up with a model law and convention on mediation. And they have noted that the increase in international and domestic commercial disputes is looking for alternatives beyond those options of litigation and arbitration. And especially looking at the benefits of mediation. And in the convention preamble, you will see that of reducing instances where a dispute leads to a termination of a commercial relationship, the cost that I mentioned earlier, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. And then they've gone on to say that they're convinced that the establishment of a framework of international settlement agreements for mediation is acceptable to states with different legal, social, and economic systems. And if you recall the few countries that I mentioned at the top of my talk, they included states governed by Islamic law, common law, by civil law, and variations. But yet, there is a ringing endorsement to the fact that in matters, mediation must be strongly considered. In fact, they have tried to, because of lack of full agreement, limit the applicability of the convention. I'm a member of the UNCITRAL Working Group 3 through Law Asia, and I've been attending their sessions, and we had a lot of discussions on the applicability of mediation to investor-state disputes. And there is hesitation in many parts of the world, but there is also very strong support for it. Very strong support to say that even if it is a sovereign function, even if it is a very seemingly intractable issue, should there still be some scope for a process which is consensual and non-adversarial. So even though this convention limits itself to situations where the parties have again the same option under the New York Convention on limiting it to commercial disputes, but they've also tried to limit it to applying to consumer disputes and personal, family, household purposes, family inheritance, employment law, and they also have said that if there are state parties that are involved, then that can be another source for reservations to be made. So in that sense, it is a very humble but very important first steps. I would encourage the students to please look through the convention. For example, there are settlement agreements that are already enforceable as if they were arbitral awards. So there should be no confusion that the lack of ratification, for example, by states like India, who may have signed but not ratified the mediation convention, the debate as to whether they should be enabling municipal law, etc. None of that can come in the way of a settlement agreement that has been otherwise recorded and otherwise enforceable as an arbitral award under separate legislation. So very clearly, this is a convention that contemplates that space has already been carved out for certain forms of settlement and is seeking to expand that space and not limit it in any way. The places of business is somewhat relevant to determine whether the convention will apply. The settlement is again required to be in the New York Convention, but since it's a 21st century document, it contemplates it can be in electronic communication. And finally, in Article 2.3, there's an attempt of saying what mediation is according to the Mediation Convention, which is a process irrespective of the basis upon which the process is carried out, whereby a party amicable settlement of the dispute with the assistance of a third person or persons that is lacking the authority to impose a solution upon parties to the dispute. And so, in the way that the pen is equally here, the mediator is hailed by his or her lack of power to impose a solution. But that lack is truly a strength. The so-called lack of that power allows parties to trust, to confide, to lay bare issues which they may or may not felt comfortable in another place. And therefore, this position that the mediator finds themselves in of lacking authority to impose a solution is a very creative space. It is left to parties, counsel, neutrals to imagine how to use the creative space. And which is why this is exciting and forbidding as a process, because it is not a straight line process. It's often said, for example, of Edward de Bono and lateral thinking, there are different forms of problem solving. There are certain problems that are straight line problems. There are other problems which are loopy problems or problems with many facets. The ultimate argument in favor of mediation in every context, I will not say in some context, I'm saying, making a more absolute statement of every context, is this: that attempting mediation has the ability to either, at the very least, limit the issues in dispute, or even lesser than that, to identify the priority, the proper priority of issues that deserve resolution. Quite often, without attending this process, without conversing with the other side, especially at a time of conflict, one loses sight of the scope of reduction of issues. And quite often one is running to battle with a variety of issues. Equally, amongst them, a sense of priority or perspective is also at jeopardy with a lack of a round understanding of the relationship between the parties. So again, the convention allows for that. There are, of course, some more general principles that you will see, that it has to be that convention shall enforce settlement agreements in accordance with the rules and the procedure. And then in Article 4, you will see the requirements for reliance on settlement agreements, that it has to be signed by parties. Evidence that a settlement agreement has resulted from mediation should be there, such as, and then either the mediator's signature or signed by the mediator that the mediation was carried out, attestation by the institution, or in the absence of this, evidence acceptable to the competent authority. Again, we are living in a world where the online dispute resolution world is extremely creative. You have platforms like Clearos, which are settling disputes by jury, as it were, which is tech disputes or cryptocurrency, entirely excluding the legal profession from the process. and they're there, they're acceptable. Platforms as well. There are many that have been burgeoning even in India. There's a group that I'm a part of called Autonomy, and it's a group that brings together software engineers, entrepreneurs, lawyers, policy folks to try to, and there are also various presentations made to the Niti Aayog. And the Niti Aayog itself has come out with its paper on ODR, identifying the various techniques. Why am I mentioning this? Because again, in the midst of the pandemic, we had startups like PandaDocs and others that had e-verified documents. And so the requirements of Article 4 very consciously have kept away from having a 20th century solution to 21st century opportunities. And so the room is left open.
Point that you raised, this Niti Aayog point that you raised. Permit me, I'll just ask you those questions. You're muted, Mr. Jaisema. Yeah.
Yes, go ahead. I thought that's the easiest way to stop myself.
No. I sorry, there's some disruption. No, because as you were mentioning the Niti Aayog note on mediation, it just struck me that, when you were talking about signing of this convention last year, 46 countries signed, which was the record for any UN trade convention before that. And so even in the middle of a lot of turbulence last year, this was signed. But if you look at the ratification process, very few of those countries which even initially signed this agreement ended up ratifying it, and it's been more than a year now. So as far as India is concerned, what do you think is the reason we are not ratifying it so far? And is there a timeline that you see going forward which sort of will allow us to ratify this agreement? Because otherwise in our law, domestic law, there are specific pockets where mediation is institutionalized. So whether it is the Companies Act, the RERA Act, Commercial Courts Act, most courts have a mediation program. So what is stopping our policymakers from ratifying this convention that we so willingly and enthusiastically signed last year?
Well, I'm not in the seat of power to answer that question, so I can only guess at it like you would. But this is precisely why with UNCITRAL there are three countries, that is Japan, Australia, and India, where we have national coordination committees in addition to the delegations that are formally sent by our governments to UNCITRAL. So there is an opening of space for dialogue and for ideas. So I cannot comment on the timelines or the reasons why ratification is held up for a point. But I will say this, that there is of course an element of suspicion with every new idea, be it FIRE or be it the Singapore Mediation Convention. Man has always feared new ideas. And so I suppose there must be an element of let's wait to see what the other person does playing out. But more seriously, I think the concern that some states would have is to ensure that there are robustly independent, non-biased, and lack of a better word, non-corrupted settlement agreements that are formed, which enhance credibility in the process. And so, but this process, more than any other, depends very much on the people running it.
Yeah.
With courts and arbitrations, you have precedent, you have procedure, you have other crutches to hang on to. And so, even with we can have some scope for damage control.
Yeah.
Whereas here, it is now left to the mediator to be able to determine whether they're being taken advantage of by parties by not telling them precisely what this dispute is about and getting them to come in and sign a document and claim that there's a binding mediation agreement but underlying issues have actually been concealed, they've not been brought to the fore. So there is an element of fear of abuse of the process. That is for sure there. And those may be some of the concerns that are holding up the process.
Right. One final question I had based on your remarks. What are the learnings we can take from the enforcement of cross-border arbitral awards under the New York Convention to ensure that adherence to this convention, the Singapore Convention, is much better? Because one big challenge that we faced under the New York Convention is that those two grounds of public policy and the dispute not being arbitrable. Those same grounds have also been included in this mediation convention also. The Singapore Convention also talks about cases and courts can refuse the enforcement of cross-border mediation agreements if it is against public policy and if the dispute is not subject to be governed under mediation. So given the experiences and the learnings we've had from the arbitration convention, what can we do to ensure better enforcement of cross-border mediation awards under the Singapore Convention?
See, the word better enforcement is not the only issue at hand. We need robust arbitrations and robust mediations. The issue of suspicion around it, either using those two words that you mentioned or any other, can be reduced to a large extent by ensuring the process is robust and there is a
I think there's a problem with Mr. Jayasima's video. Dr. Garg, can you also?
Yes, there's a problem.
Okay.
It is paused.
This might be something momentary in Shreyas. I do hope that he will rejoin.
Yeah, I think so. So maybe, Dr. Garg, should I just ask you to maybe share your observations on the ancestral model law while?
I think Shreyas has joined.
Yeah, I'm keen to hear Dr. Garg's view, but very quickly to say what I was saying, that the focus should be on training mediators in the process, convincing parties of how they should conduct themselves in a mediation, identifying how the process can be abused, so that early on, you don't wait till the settlement award comes out and then agreement comes out and the court proceeding to try to talk about abuse. You sensitize parties, all parties concerned at the very outset, so that early checks and balances are put into individual matters, that robust institutions are in place to be able to monitor the progress of matters. I feel that the idea is not an option. It's not an option to whether mediation is on the table. Mediation is a right, and the lawyers may be hesitant, but the parties want it. Corporations want it. States, by signing this instrument, have said that they want it. Now the question is, how do we properly implement it? How do we? And that is the only question before us. Not should we consider mediation. The question is how. That's the only question. And so now the question, in my view, should be on proper training, increased awareness, and putting out best practices, and then in this way building institutions that have credibility, and in that sense reducing the scope for suspicion or challenge at the time of enforcement. But I'm keen to hear Dr. Garg's comments.
Thank you, Mr. Jayasima, for such a wonderful sort of conversation. We now go to the second speaker for this session, Dr. Risham Garg, who will talk about another very important issue related to cross-border trade, which is this unsettled model law on secured transactions from the year 2016. One big challenge that businesses face all over the world is having a uniform law for security transactions, which creates greater certainty in the day-to-day business practices. And I think the unsettled model law is a big step towards ensuring a more predictable regime for security transactions all over the world, which will I believe ensure a quantum jump in the ease with which businesses can do the transactions all over the world, and correspondingly increase the level of economic activity in all countries which adopt this law. So, Dr. Garg, if you could share your remarks for about 10 to 15 minutes, after which we'll have a short conversation on your remarks. Dr.
Garg. Thank you, Apurv. But before starting on the secured transactions, maybe I can offer some of my views to the deliberation that was started by Mr. Jaisimha.
Yeah.
So I really appreciate, and this mediation convention is also a milestone, and it's a these are complementary texts, complementary instruments, and it's a complete legal regime, whether you call it arbitration and mediation, but certainly what we require is a robust legal regime for the adjudicatory process. So there is no doubt that the courts cannot take up all the burden, and there are some matters of expertise where there is a technical knowledge and understanding is required, and very cheap, very fast, and that is why the arbitrations were developed. And similarly, to ease that process further, the mediation or the other ADR process has been developed. So it has been very elaborately elucidated by Shreyas. I won't have any other further opinion on the enforcement of the mediation settlement agreements, because I do believe, and I probably do agree with Shreyas, that the first stage is for the capacity building of the people who are undertaking this exercise. And I do believe that, if I can safely say, that we may have a legal regime in place to ensure the settlement. But apparently, if we see the cases and the practitioners know, they are hearing those cases, they are viewing those cases, it appears the major challenge will be regarding the sanctity of the process, how that settlement agreement or that award has been reached. So I agree with Shreyas, and if Shreyas has to any counterpoint, I would welcome that.
No, thank you very much. Please excuse me, I need to attend a matter in court, so I'm obliged to the invitation, but please excuse me in my absence. Thank you.
Okay, so thank you. I think we must thank Mr. Shreyas Jaisimha for his valuable remarks, and we look forward to him joining again tomorrow in that session on cross-border insolvency.
Thank you, Mr. Jaisimha.
All right. So now, what is the secured transactions? So for the trade, as we have discussed, the there is trade, and to enable the trade, there is a requirement of trade finance. Now, the trade finance needs to be enforced through a particular mechanism, which is basically business mechanism. There are financiers, there are banks, there are financial institutions, there are factors, brokers who are managing these trade finance instruments. Now, the model law on cross-secured transactions is also it suggests states to develop their legal regime to support and promote the secured transactions, to promote the trade, especially amongst the MSMEs, because the MSME are in great need of finance, and they might not have that amount of security. The big industries, the big corporations, they have good amount of collateral. They generally might not find difficulty in taking loans. They will have other collaterals, but the SMEs, the MSMEs, they would require financing on their receivables. So receivables, there are stock in trade, there are goods which are sold, and it's not a fixed collateral or asset which is being financed. So hence, there needs to be some legal regime which, on one hand, safeguards the interest of the financiers, but on the other hand, also promotes that easy and cheap availability of finance to the trade. Now, the purpose of this model law is to assist the states in developing a modern secured transactions law dealing with security rights in movable assets. The model law is designed to increase the availability of credit at a more affordable rates by providing an effective and efficient secured transactions law. Now, the model law is based upon the assumption that to the extent that a secured creditor is entitled to rely on the value of the encumbered asset for the payment of the secured obligation, the risk of non-payment is reduced, and this is likely to have a beneficial impact on the availability and the cost of credit. The model law is intended to be useful both to states that currently do not have efficient and effective secured transaction laws, and to states that already have such laws but wish to modernize them and harmonize them with the laws of other states that have modern secured transaction laws that are generally consistent with the model law, basically. So again, there is cross-border trade. Every state has their independent legal regime, and the purpose of model law is to suggest the states to adopt the law which will be having some sort of a uniformity and or common aspects across various countries' legal systems. So they won't have to face those legal issues in a different law, different legal regime, and everybody will, be very comfortable that we are comfortable with the legal system because it is more or less the same or adopting some uniformity. Now here I would like to take cue from our earlier session in the introduction. In the inaugural session, the valuable comments which were made by the Untitral legal representative, Mr. Luca Castellani, where he mentioned that although he was referring to the CISG convention, but however, the role of the Untitral instrument the role of the Untitral legal instruments to promote the uniformity and harmonization, and especially why it is beneficial to the SMEs. SMEs cannot afford that cost, So big industries, big corporations can afford that cost. They can go to the legal counsel, they can draft contracts, they can vet the contracts, they can undertake expensive legal due diligence. So these are all transactional aspects which big corporations can afford, but the SMEs cannot afford. So a purpose of some of these Untitral texts is also to ensure that there is a uniformity in law, so that the cost of these SMEs or the MSMEs do not increase. At least the legal cost can be avoided or minimized. So that is one essential purpose of the model law. Now, again, generally, I wanted to speak something also upon what is the model law and its role for modernizing and the harmonizing of laws. So, as we have seen in the case of the model law on international commercial arbitration, so this was based upon the Untitral Model Law on International Commercial Arbitration of 1984, and in India we adopted it into the Arbitration and Conciliation Act. And so that is the model law. Untitral provides a draft law that states can adopt as it is, or they may slightly modify them. It is as against or different from a treaty with which you have to adopt it nearly as it is. There are minor possibility of changes or alterations, which are called reservations that a particular state may make. So in general, states that incorporate the model law into their national law are advised to adhere as much as possible to its uniform text. Because the various jurisprudence and across various legal systems then would also be more or less uniform. They would be discussing the similar principles. We have seen that Indian courts in India usually refer to the UK decisions because the basic principles of law remain the same, so it is easy to refer to those opinions. So in case any particular model law is adopted nearly in the same content and context, then it helps. So this can help the enacting states to obtain the full economic benefit of the legal system envisioned by the model law, to avoid unintended consequences that may follow when a change in one provision has unforeseen effects elsewhere in the law, and to gain the benefits flowing from the harmonization of its secured transaction law with the laws of other states. But this certainly does not deprive enacting state of any necessary flexibility, as the model law provides options and leaves a number of matters to the enacting states. Now, as far as the model law on secure transactions goes, there are several aspects of flexibility. As I mentioned, in a convention, also some limited amount of flexibility is provided. A particular country can have reservations, so those reservations will not apply when that law is being applied in the country. However, there is always party autonomy. These are all instruments of contract, and contract law generally is a default law, and accordingly, parties may, the individuals, if the individuals want, they can create insert a clause in their contract to avoid a particular treaty, or they can suitably modify any particular provision of a law. So that we always know, that we already know is settled jurisprudence. Now there are certain examples of flexibility in the model on secure transactions as well. And some of those examples that I can refer here are, like, certain terms used in the model law may need to be adjusted to ensure that they are meaningful in the context of local law. For example, authorized deposit-taking institution, movable property, immovable property, and securities. Then, apart from that, several provisions of the model law refer within, it's again how we are using the parentheses, brackets, and or and so on. So they also use some square brackets to issues that are left to the enacting state. So these are basically issues which are on, we can say, a mandatory law, that is mandatory provisions, and hence the model law does not, make any clause on that. A very good example which I can always remember and I always refer is in the Cisg that doesn't talk about the ownership rights or the property. But when we read the Sale of Goods Act, the essential of sale is that there has to be a transfer of property. However, the transfer of property or the transfer of ownership is inherently a part of a mandatory law of a particular state. So hence it is avoided, it is not included in the Convention on International Sale of Goods. Similarly, as Shreyas has just mentioned, whenever there are deliberations on UNCITRAL texts, the country representatives, they deliberate. They say that, no, this provision, we have certain case law, we have certain jurisprudence, and it would be best avoided, or you can create a separate or a special situation where the individual state may take that call, how they need to draft, they want to draft that particular provision. So as we have seen, the model law leaves it to the enacting states to decide how to clarify in its enactment of the model law. The general rules are subject to the asset-specific rules. Another very interesting aspect which we read in the private international law is that property is always determined with lex situs, wherever the property is situated. So in case of, at least in case of immovables, so immovable property, wherever that immovable property is situated, only that state law is applicable. That is the principle of lex situs. So hence, generally to all the property, and certainly because of the security, it is considered that the individual states, for example, in India, the central bank RBI governs the and regulates the banks and financial transactions. So the central bank or the regulatory authority may have certain rules and regulations which would determine the financing of those trade and instruments. So hence, wherever there is a regulatory aspect or a mandatory law, the UNCITRAL text or model law chooses to not mention it or write it in a affirmative manner. So I think these are some of the main points which I wanted to discuss, and I think I have taken a lot of time, and I see Professor Rai is here. He's waiting impatiently. So I would request Professor Rai to start with his presentation. Thank you for allowing me this.
Thank you, Dr. Garg, for a very comprehensive and an incisive presentation. Professor Rai, if let us know whenever you're ready.
I'm ready.
Professor Rai wasn't there with us earlier. He's a senior professor at NLU Delhi, has been a partner at Luthra and Luthra offices, and is one of our senior thought leaders in the country on banking law. So, Professor Rai, over to you.
Yeah, thanks, Apurva. Okay, and Risham. Right. Now, as far as, financing, what is the topic is providing trade finance to micro, small, and medium enterprising, and also factoring. Okay. See, we are here dealing with a trade finance that is a working capital finance, and we are not dealing with what you can say a fixed loan or long-term finance. So I'm just restricting myself to this particular thing. Is my presentation visible on the screen just before I start?
Yes, okay. Professor, it is.
Okay. Now, trade finance, what are the options available for the micro, small, and medium enterprises? Okay. And limitations before we move on to factoring. Okay. Now, one type of a trade finance which can be provided, to the micro, small, and medium enterprises is secured trade, secured transactions. Now, secured transactions can be, that is when I provide a working capital finance, the financier provides a working capital finance to the enterprise. It can be either security over an existing fixed asset, which is owned by the enterprise or by the promoter. Okay. So he has the land or the warehouse or factory, whatever it is, even the machinery, it is a fixed asset, and provide the security for it. But unfortunately, what happens is that the fixed asset usually has already been acquired by a loan, okay, or it has been used for the purpose of expansion or whatever it is, a further loan has been taken on the security of it. And then the requirement of a margin which is there, which the bank will require over it. Okay. So if the fixed asset is worth, 100 rupees, then taking into requirement of margin and all, the bank will not lend usually more than 50 rupees or 60 rupees over it. Okay. So there is that particular limitation, that there is a limited finance which can be taken over the fixed asset, and that particular fixed asset has already been secured. And therefore, after margin requirements, there is nothing left to offer as a security to another. Second method is a fixed security over the receivables. Okay. That is, create a mortgage or a charge over the receivables. That is, the bank concerned takes a mortgage or a charge. Now, mortgage will be what you can say a clean assignment with an assignment back after the loan has been paid off. Second would be a charge. Charge is where the lender gets a right over the assets, but he is not the owner of the asset. Now, originally, there used to be a lot of distinction historically with regard to mortgage and charge, because in the case of mortgage, there was a clean assignment and notice and all was given to the original debtor. But now those are just of historical importance notionally, because the lender now takes a power of attorney over it. So even if on the paper it is a charge, it is as good as an equitable mortgage over those. The third is a floating charge over current assets and receivables. So the person, that is the lender, takes a floating charge. That is, see, in the fixed charge, he restrains the ability of the borrower to deal with that particular asset, his receivables. But when he takes a floating charge, the borrower still has an ability to deal with that particular asset. And difference will be here between the fixed charge over the receivable and a floating charge over the receivable will be that the borrower concerned, when he receives the money from his own debtor, though the person to whom he has given the supplies, then in that case, he can use the money as he feels free in the case of a floating charge. But in case it was a fixed charge, then he would be restrained with regard to how he deals with it. The second method by which a finance is provided is what we can loosely call the title finance. Okay. Now, title finance for the purpose of trade purposes will take normally three forms which are there. One form is, of course, retention of title clause. That is, if the borrower needs something for the purpose of meeting his orders, the financier provides him that with the goods for that, okay, retains his title over the goods, okay, and what is produced out of that particular good, and he retains also the title over the money which is then received by the borrower from the sale of those goods. As an example, let me say, if I am a jeweler, then my financier will provide me the gold. He will retain the title over the gold. He will retain the title over the jewelry which is produced out of the gold. He will retain the title of the money which I will receive from the sale of that particular jewelry. And after getting that particular, that is, if I receive the money, the title is that of the financier, and the financier concerned will then get his share of the pie, and then the rest of the money I will keep it with me. Okay, so this is one method by which the financier ensures that he is paid off, that is first in the line in queue in the event I go bankrupt. The second method by which the financier seeks to ensure the payment is bills of exchange finance. That is, I will write out a bill of exchange ordering the person to whom I have sold the jewelry that the person concerned shall pay that money to my financier. Okay. So with this particular bill of exchange, one thing is that I am a type of a till the person concerned, that is the person to whom I have supplied, my distributor, he accepts it. I am the person who is primarily liable on that particular bill of exchange. After he accepts it, in that particular event, he will be the person who is primarily liable, but I will become his guarantor. Now, the advantage of a bill of exchange is that once a bill of exchange has been written out, there is no ifs and buts with regard to it, whether the payment has to be made or not. He is, of course, my distributor has an option whether he will take the payment or he will accept it or he will not accept it. But once he accepts it, there are no ifs and buts with regard to it. On that particular bill of exchange, he can't raise any questions of equity between me and him. Okay, that the jewelry was fake or something of that sort, those arguments he cannot raise with regard to it. And this particular bill of exchange can easily be transferred to someone whom the financier wants to sell it. So raising of finance on the basis of this particular bill of exchange is very easy, because in the transfer of this particular bill of exchange, as what you can say, negotiation of this bill of exchange, no further stamp duty and all is necessary. And everyone who becomes a party to it, that is the financier, if he sells it, he also is a guarantor. So the value of the bill of exchange arises. So there is an advantage with the bill of exchange as a means of finance. Now that those particular advantages will be there, of course, with regard to it, but one has to remember one thing is that in the case of bill of exchange, wordings and how it is drafted are much material. And the second disadvantage which is there is that defaults on any part of any person absolves the parties of the rights to it. And there are also many ifs in a short this I would be able to say. I should say the third method of title finance is what we generally call factoring, and in United States is called forfeiting. Now, what is factoring and forfeiting? Okay. Now, factoring is what you can call, in India, it is an assignment of actionable claim. Okay. It's an assignment of an actionable claim by a person concerned. Actionable claim as defined in Transfer of Property Act. Okay. Section 3 of the Transfer of Property Act defines an actionable claim. In other common law jurisdictions, it is called chooses in action. Okay. So it is an assignment of an actionable claim. That is, the debt which is due to me, that particular debt I assign to someone under section 130 of the Transfer of Property Act. I assign to a third person. So that is factoring of an action. Now, usual transaction mode which is followed by the financiers is that normally when an factor effect is provided for the person, that is, see, what happens in the case of a factoring is I need finance from the bank concerned. Now, bank will not want to give me finance because I do not have the money to give it, so any security to give it to me. So now receivable is one thing is I can give that particular thing as a receivable. But when I give a security over that particular receivable, there will be ifs and buts because it is a security with regard to it, whether equity is between us or not. We'll come to that later on. Equity between me and my distributor. So what the bank will want is it will take in this particular case is assignment of that particular actionable claim. Whatever the distributor owes to me, that will be assigned to the bank concerned. Now it is the owner of it. Once it is the owner of it, it can directly claim that particular money from my distributor. Now, here what happens is the bank, with regard to the actionable, that is the factoring business, if it is a part of the factoring business, what the bank can do is that it will now look into, because now the risk is not me, but my distributor. Because the risk is not me, but my distributor, the bank concerned will now look into the risk profile of my distributor. So if Reliance Retail is distributing the goods which I have produced, then what it is looking at is whether Reliance Retail is a worthwhile debtor or not a worthwhile debtor. So now it is the distributor's credit worthiness which becomes important to the bank concerned. Okay. So what it will normally do is that it will give me a usual mode. It will give me two thing it will look at is, first of all is it will buy those particular actionable claim, or you say chooses in action from me. Second thing is it will, instead of paying me the full amount, it will pay me a part of the amount concerned. Okay. That is the second thing which it will do. Third, then that is because that is its margin. In addition to its margin, it will take it will have against me a right of recourse. That is, if Reliance Retail defaults, then in that event it will get the money. That is, I stand as a guarantor and it will sell back this particular actionable claim back to me. So this is the third thing which it will reward. That is a right to recourse which it will retain. So for this particular right to recourse, it will retain an additional margin. So let's take, for example, Reliance Retail owes me 100 rupees. It will give me 95 rupees. 5% is its commission. And another 5 rupees it will retain as a separate account, which will be then against the right of recourse. That is, if Reliance Retail defaults, then it will get that money back from me. So this is the way the factoring or forfeiting normally happens. Now, for the transaction of factoring, Section 130 requires it to be in writing, but let us remember, it is something which can also happen in equity. Okay. In actionable claims, as per Section 130, has to be in writing, but it's not necessary that each of the transaction, that each claim I can have to sign it over. It can happen in equity. Second is that there is no necessity of notice to the debtor concerned. I need not give a notice to the debtor, but giving of notice to the debtor gives me first right. Okay. Now the rule is in Dearly versus Hall that the person who is first in time of giving the notice to the debtor, that person will have a precedence, the first right. So this is the second important aspect. Normally, notice should be given to the debtor by the assigner or the assignee as early as possible for the assignee to have the first right. Okay. Third things you have to remember is that in the case of factor financing through the medium of factoring, the debtor concerned might have certain rights against me. Okay. So if the original debtor, say, he has got a right of set off against him because the goods supplied were defective, then he has certain rights. So if I assign it to the bank, the assignment will be subject to those rights which the debtor, original debtor, has against me. So if I had supplied defective goods and out of 100 rupee, 20 rupees has to be retained, that particular 20 rupees which I have to give back to the original debtor, the assignee takes it subject to those rights. But as per as actionable, what happens is those rights are there only till the date of the notice. After the date of the notice, those particular rights concerned are no longer, no equities. Debtor cannot accrue any more equities. So he can ask for equities only till the date of the notice, not after the date of the notice. Priority of competing interest, we have already done it, or whosoever is the first in time to notify the original debtor. Now, who can acquire an actionable claim or who can't acquire actionable claim? People who are associated with the enforcement of justice, they cannot acquire actionable claims. Others can acquire, but those associated with enforcement of justice can't acquire. That is the one prohibition which is there. That is lawyers, judges, and so on. And of another is that prohibition on assignment or creation of security. That is, if the debtor concerned has prohibited me to assign this particular debt to a third party, then I can't assign it or can't create a security over it. But I can assign or create a security over it in equity. This is the third restraint which is there. Now, after the Factoring Regulation Act of 2011, certain changes have occurred. Okay. Now, let us remember this Factoring Regulation Act has not done anything with regard to assignment of actionable claims. Okay. And this is a very gray area which we will have to look into it, because the Factoring Regulation Act has sought to amend the law with regard to factoring, but it has not amended the law with regard to assignment of actionable claim. And there is a difference between assignment of actionable claim and factoring as it is, because the Act has sought to do is that only a factor can do factoring business. Now, there would be a difference between an assignment of an actionable claim and a factoring business. Okay. Factoring business is something which you do in the regular course of event. Okay. That is, you continuously, a financier who continuously does take over actionable claims, he will be into a factoring business. But a person who buys a debt once in a while, he is not into the business. So we have to understand there would be a distinction between a mere acquisition of an actionable claim or a one time at once in a while and a regular business model which is based upon acquisition of actionable claims. Okay.
Before you go ahead, the next session was supposed to start at 12:45. So if you could just wrap up your presentation so that we can see if we have some questions and then wrap up the session.
I'll just wrap up in 5 minutes. Okay.
Yeah. Thank you.
Second thing is we have to understand is factoring business as finance or whatever is that the Factoring Regulation Act provides with regard to it that factoring as a means of financing of credit can also be there. Okay. Only thing is what it says is financed by banks in the ordinary course of business of security of receivables. That is something which is excluded. So we have to understand what it seeks to do. What here it seeks to do is that in the ordinary course, that is floating charge, a method of creating floating charge over the receivables, that would be excluded, okay, by banks. Okay, that is not a factoring business. But fixed security over the receivables, especially mortgage, creation of mortgage over the receivables, that would be regarded as factoring business. Okay. So this is one important change which the Factoring Regulation Act has made is that only those who are licensed as factors can, or specifically mentioned as factors, they can do the factoring business. No one else can do it. And when we say factoring as a business, it can be clean buying of that particular assignable as actionable claim, or mortgage of the actionable claim will be there. Now, where this particular law departs from the ancestral is in few respects. Okay. First is commingled funds. That is, if the assigner concerned receives the money, normally the money ought to go to the assignee, but if the assigner receives the money, the assigner is supposed to hold the money for the benefit of the assignee interest as per the Factoring Regulation Act. Okay. So if I have sold the actionable, what is due to me to the bank, and my distributor still gives me the money, I hold it in trust for the bank. Okay. Now, this is what is provided by the Factoring Regulation Act. Okay. Now, even if I mix this particular money with other monies, my part of it will be supposed to be held in trust for the assignee, for the bank. Ancestral model, Article 10 of the ancestral model provides that if I commingle the funds, that is the sold actionable claim money with the money with my own money, then a security is created over it. Okay. Now there would be implications of it as far as law is concerned. Trust is a better model than the creation of security as per ancestral model. Okay. Second thing which we have to factor is that, okay, where the Factoring Regulation Act departs from the old law is that the defenses, as I told you, that the defenses of right of set off is available till the giving of the notice. Okay. Now, as per the Factoring Regulation Act, the defenses which the original debtor has, he will retain, though he will have not only the defenses which he has till the giving of the notice, he can also create more defenses and more equities even after the notice has been served to him. That is the second respect where this particular law, I mean, it doesn't depart from the ancestral model. Ancestral doesn't talk about it, but it departs from the old law concern. Third aspect which we have to figure out is where it is of concern is that this Acts deals with only with respect. What it says is that you must be knowing with regard to it, in case of delayed payment under the Micro, Small and Medium Enterprises Act, the Micro, Small and Medium Enterprises Act is entitled to payment of a penal interest. Okay. Now, here in this particular statute, what this says is that the penal interest shall be held over by the that is shall be given to the assigner. Okay, that is, if the original debtor has to pay the penal interest, then it will be given by the assignee to the assigner. That is, I have sold my actionable claim to the bank concerned. Though I have sold the actionable claim to the bank concerned, if Reliance Retail is late in the payment, that particular money, Reliance Retail, when it pays, the assignee has to give it over to me. Now, it does not make normal sense if the bank has bought the actionable claim in a clean manner. Okay, this is second problem. Third thing we have to figure is that ancestral model law requires for a registration of the secured transactions. Okay. Now, Section 7, if it was a ancestral law with regard to its secured transaction, Section 77 of the Companies Act requires a registration of it. There is no problem with regard to it. Now, Section 20 of the regulation act also requires its registration under the SARFACI Act. Okay. Now, registration under the SARFACI Act this particular requirement of under Section 19 of the registration under the SARFACI Act, that does not serve any purpose itself if it is a clean transaction. That is, it is a factoring not as a security but as a complete sale of the assignable. Now, another aspect why
if you could just wrap up so that we can end the session.
I'm just wrapping up. It's the last point. The last is that there's a problem in regard to it is that payment of stamp duty. Okay. All the transactions with regard to assignment of debt require a payment of stamp duty, and many of the states have got pretty high stamp duties chargeable upon it, which do pose a problem. Okay. Thanks a lot. Okay.
Thank you. Thank you, Dr. Rai, for a very, very comprehensive presentation on financing for MSMEs and especially on factoring transactions. In fact, the reason we sort of discuss this topic is because this is one of the important decisions taken by the government in the last 6 months to provide reliable and quick access to credit for MSMEs. Now, under the Factoring Act, all NBFCs are allowed to undertake factoring transactions. The requirement of a separate registration certificate under Factoring Act was done away with recently by the government so that more MSMEs could use the TREDS platform, and more NBFCs and financial institutions would also use the TREDS platform to provide credit to MSME sector in the middle of the pandemic. So with that, we come to the end of this session on creating a robust legal regime for cross-border trade. Easy access to credit and quick resolution of commercial disputes are two very important components of any discussion on cross-border trade and how to improve the ease of access for companies which are indulging in cross-border trade, and which we've covered both these aspects of the legal regime in our conversation. We've spoken about the Singapore Mediation Convention, which talks about quick resolution of commercial disputes, and we've spoken about the access to credit for MSMEs through factoring transactions and also under the ancestral model law. We thank all our speakers for providing such comprehensive presentations on all three aspects. I now request Isha and Ria to take over the session.
I would really like to thank the speakers of session 1. It was indeed an enriching session. I think now we would proceed to session 2 as it has already been delayed by like 15 minutes. Thank you.
Thank you.
Thank you, Isha. I think we have all the speakers for session 2 present amongst us. The second session that we have today is on access to commercial justice. And in this session, the session will be moderated by Professor Yogesh Pai. Professor Pai is currently the co-director of Center for Innovation, Intellectual Property and Competition at the National University. And he specializes in intellectual property law and has cross-cutting research interests at the interface of IP with competition, trade, and economic policy. On the panel for today's session, we have Mr. Hamish Lal. Mr. Lal joined Akeem Gumstraws Hauer and Feld LLP as a partner in its international arbitration practice. He's a renowned top practitioner and he covers mostly international construction arbitration in relation to complex and high-value international projects. We also have with us Mr. Abhay Gand on the panel today. He's practicing as an international arbitration consultant since 2013 and specializes in international construction, infrastructure, energy, oil and gas, power, sale of goods, and white-collar crimes. Also on the panel is Mr. Akshay Sridhar. He holds an LLB honors from National University Delhi and an LLM from MIDS program in Geneva. He's an associate in Queen Emmanuel's Paris office and focuses mostly on international arbitration as a part of his practice. Also on the panel today with us is Mr. Animesh Sinha, who started his practice with Karanjawala and Company. And soon after, he initiated his independent practice, and he represents Top Insurance Company. Currently, he is a partner at Animesh Sinha and Partners, which is a multidisciplinary law firm, and has a considerable experience in dispute resolution, contract preparation, and corporate advisory. I would now call upon the moderator for the session, Mr. Yogesh Pai, to take over and steer the discussion with all our eminent guests. Just one more thing, I have the presentation of all the speakers ready and stored in the storage. So whenever anyone needs to speak, please let me know and I'd play the presentation and you would be free to control it. Thank you.
Wonderful. Thank you, Ria. I hope I'm audible to everyone. Thank you, Professor Garg, for giving me this opportunity to moderate this very important session. The session is on commercial justice. Access to commercial justice. Ria has already introduced you to all the 4 esteemed speakers in this panel. Without much ado, I would like to call upon each of these speakers. Towards the end, we are going to have a small bit of floor discussions because there is not much time we have spilled into. We are running behind the schedule. We'll have to continue with the session, and I'll start with Mr. Abhay Gand. I think we can't hear. Ria, can you hear Abhay?
No, sir. Mr. Abhay, you're not audible.
You're not audible.
Well, you're unmuted, but for some reason you're not audible. Right?
I think if Mr. Gand uses a headphone, I think it should be possible.
Is it okay now? Can you hear me?
Yes, perfect.
Yes, perfect.
Perfect.
Okay. So keeping in view the theme of this session, let me begin with an arbitration case where CISG was applied by the arbitral tribunal. I was a part of this case, so I'm going to start off with this. So the claimant in this arbitration was a privately held Turkish corporation engaged in manufacturing of biodiesel fuel as its plant in Turkey. The respondent in this arbitration was an international trading company based in Singapore that is active in the petrochemical sector. Several disputes arose between the parties out of an agreement entered into by the claimant as the seller and respondent as the purchaser of sale and purchase of biodiesel. The agreement provided for sale and delivery of claimant to respondent of 12,000 metric tons of biodiesel in bulk in of 6 shipments of 2,000 metric tons each. Section 43 of the agreement provided the choice of law clause. The clause reads as follows: this agreement shall be governed by and construed in accordance with the Swiss law. Section clause 44 of the agreement provided any dispute, controversy or claim arising out, involving or relating to this agreement or the breach, termination, or invalidity thereof shall be referred to, settled, and finally resolved exclusively by arbitration in accordance with UNCITRAL arbitration rules at its present in force. In application of the UNCITRAL arbitration rules, the appointing authority was the Zurich Chambers of Commerce. The arbitral tribunal shall be composed of 1 or 3 arbitrators. The number of arbitrators shall be decided by the agreement of contestant parties within 15 days after receipt of the respondent of the notice of arbitration. Failing such agreement by the appointing authority, the provisions of Article 5 of the UNCITRAL rules are expressly modified hereby. When deciding on the number of arbitrators, the appointing authority shall take into account the amount in controversy and the complexity of the issues to be determined. The sole or 3 arbitrators, as the case may be, shall be appointed by the appointing authority. The arbitrator shall be fluent in English language. The language of the arbitral proceeding shall be English. The place of arbitration shall be Zurich. So one of the points in dispute between the parties was whether the CISG was applicable in the present case, because the clause 43 never just said this agreement shall be governed by and construed in accordance with the Swiss law. So while the claimant submitted that the CISG applies in this case, respondent took the position that the CISG does not apply and that the party's intent must be construed to refer to the Swiss Code of Applications. The parties are domiciled in Turkey and Singapore. The CISG was in force in Singapore when agreement was made, but not in Turkey. Hence, Article 1A of the CISG would apply, and any application of the CISG would have to be based on the Article 1B of the CISG, read in conjunction with Article 187 of the PILA, which is the Swiss private international law, and which says the arbitral tribunal shall decide the dispute according to the rules of the law chosen by the parties, or in the absence of such a choice, according to the rules of law with which the dispute has the closest connection. So it appeared to be the common ground between the parties that the agreement was in the nature. Therefore, under the circumstances, 2 questions arose for determination. The first is whether the choice of law clause contained in clause 43 of the agreement in its construction expresses the intention of the contracting parties to refer to Swiss law intended as a domestic law applicable to purely domestic contracts in Switzerland. This is a question which depends on application of Article 187 of PILA and eventually construction of clause 43 of the agreement. The second question is whether the exclusion of CISG can be rested on Article 6 of the CISG itself. So, is the application of CISG excluded by clause 43 of the agreement? Clause 43 of the agreement refers to Swiss law without making any distinction between parts of Swiss law. In absence of such a distinction, when contracting parties agree on the proper law of their contract, the choice of a legal system must be reasonably presumed to relate to the system chosen as a whole. This appears to be all the more when the parties' agreement is international in nature and chosen law contains rules which are specified, intended to apply in international contracts. Whenever parties to a particular agreement intend to make a choice of law clause which is different from standard clauses in any respect, in that they want to refer to only the specific part of the system so chosen, or to opt out of a part of the system so chosen, they must express their intention in a clear and an unambiguous manner. So, is application of CISG excluded by Article 6 of the Vienna Convention? Article 6 of the Vienna Convention reads as follows. The parties may exclude application of this convention or subject to Article 12, derogate from or vary the effect of any of its provisions. The wording of choice of law clause made by the parties and contained in clause 44 of the agreement does not expressly refer to the CISG as set out above. However, an exclusion of CISG pursuant to Article 6 of the CISG could also be agreed by an implied term. In the present case, the system of law chosen, Swiss law, is the contracting state of the Vienna Convention. It is the prevailing view of the choice of law of a contracting state, does in principle not amount to an implied exclusion of the application of the Vienna Convention, as the convention is part of law of land in all contracting states. Further, because of the exclusion of the Vienna Convention is operative under Article 6 of the Convention only, insofar it is an agreed exclusion, in other words, an exclusion supported by the actual intention of the contracting parties. Existence of an implied exclusion should, in the tribunal's opinion, not be too readily admitted. As explained earlier, the parties have referred to Swiss law in general without any specific distinction In particular, they did not agree on application of rules of the contractual obligations, which is the Swiss law. Further, there is nothing in the evidentiary record that would suggest, much less establish, an agreement to exclude the Vienna Convention pursuant to Article 6 of the CISG in favor of the contractual obligations. Based on above, the arbitral tribunal reached the conclusion the Vienna Convention applies to this agreement. Going further on the issue of contract formation and drafting, I would like to refer to the CISG, wherein the formation of contracts is regulated by Part 2, Article 14 to 24. Article 11, 13, and 29 also provide insight for formation of contracts. In general terms, with regards to contract formation, the CISG adopted the traditional concept of contractual obligations, which provides that contracts shall be formed as a result of two declarations of intent, offer and acceptance. In the doctrine, it is accepted that in cases where complex negotiation processes have taken place and where it is difficult to distinguish between offer and acceptance, substantive consensus can generate solutions, and CISG will establish scope of application. So, offer is an act of law, therefore it has to comply with applicable laws aside from CISG. Pursuant to the CISG Article 14, a proposal for concluding a contract addressed to one or more specific persons constitutes an offer. It is sufficiently definite and indicates the intention of offerer to be bound in the event of acceptance. It can be derived from this definition that in order to establish an offer, two conditions should be present: intention of offerer to be bound and a sufficiently defined proposal. What is sufficient definiteness? Article 14 provides that a proposal is sufficiently defined if it identifies the goods and expressly or implicitly fixes or makes provisions for determining the quantity and the price. Another component of the proposal is the intention of the offerer to sell the product. An offer does not always seem like a proposal. It can be in the form of an invoice or a letter of acknowledgement. Article 8 and 9 will also find its place in understanding the principle of surrounding formation. In a general sense, Article 8 stipulates the intent of a party is interpreted in accordance with his intent. Article 9 provides that parties are bound by usages and practices, which is lex mercatoria, that have been agreed upon between them. Other articles of the CISG can also be in question in relation to Article 14. Article 14 can be interpreted as an offer not being made where price is not designated. On the other hand, it can be derived from Article 55 that a contract can be validly established without determining price, expressly or implicitly. In these cases, it is accepted the price is determined with reference to the same products sold under similar cases. In the doctrine, it is accepted if price can be established when all of the terms of the conditions are considered. It must be accepted that a valid offer has been made. Intention of the offerer to be bound. Offers addressed to one or more specific persons are considered as invitations for offers. Mass distribution of catalogs, brochures, and websites will not constitute an offer, but will be accepted as invitations unless it is clearly established to the contrary. In cases where it is difficult to establish the intent of the offerer, Article 8 can be taken into consideration. In considering the third subsection, in determining the intent of a party or the understanding that a reasonable person would have had, due consideration is to be given to all relevant circumstances of the case, including usages and any subsequent conduct of the parties. Going further, the effectiveness of the offer. An offer will become effective when it reaches the offeree. Article 24 provides that an offer will reach the addressee when it is orally made to the addressee or delivered in any way personally to his place of business or to his mailing address or to his habitual residence in case where contract is formed through electronic messaging. Article 24 states that if addressee accepts an electronic message when it enters the addressee's information system, and in order to apply this provision, addressee must have an information system. If the electronic message is sent to another information system designated by the addressee, the message is deemed to be received when the addressee becomes aware of the message. Withdrawal and revocation of the offer. In order for an offer to be withdrawn, Article 15 states that withdrawal should reach the offeree before or at the same time as the offer. It should be noted that the revocation and withdrawal are distinct terms from each other, having different meanings under the CISG. Revocation of an offer is regulated under Article 16 of the CISG. An offer is revocable when it reaches the offeree before the acceptance is dispatched. In some instances, the offer cannot be revoked if there is a fixed time, or it has been established that it is not irrevocable. And if the offeree relies on the offer and has acted in reliance thereof, the offer cannot be revoked. Acceptance is regulated under Article 18 to 22. And acceptance can be made as a statement by the other conduct. It is important to note that the silence or inactivity is not considered as an acceptance under Article 18. As is indicated under Article 8, 9 plays an important role when interpreting offers and acceptances. In cases where any usage or practices, again, lex mercury, agreed upon, suggests that otherwise, silence or inactivity can also be interpreted differently. Effectiveness of the acceptance. An acceptance is effective when it reaches the offeror. If an oral offer is in question, it should be accepted immediately, unless circumstances imply otherwise. In some instances, there is a fixed time within which to accept the offer, pursuant to Article 20. For those periods that are stated in a letter or a telegram, the time begins to run when the telegram is handed over for dispatch, or the date indicated in the letter.
Mr. Gain, if you can kindly conclude.
Yeah.
Because we had allotted 10 to 12 minutes for each presenter.
I'll just take a minute. So, thanks. Or it is not so stated, the date shown on the envelope. Official holidays and non-business days are included in this period. Only if the last day of the fixed period is an official holiday or a non-business day, the period shall be extended for the first business day. If such a fixed time is not regulated, then acceptance shall be made within a reasonable time. A late acceptance is not effective unless an oral statement or notification is made to the offeree. In order for a contract to be formed under the CISG Article 23, an acceptance to an offer should become effective once the contract is formed. All of the following engagements can only be interpreted as amendments to the offer. Going further, rejection of an offer. Rejection of an offer is stipulated under Article 17. Accordingly, a rejection must reach the offerer in order to terminate an offer, even if the offer is irrevocable. A counter offer is regarded as a rejection of the offer when it includes additions, limitations, and modifications. However, acceptance, which is intended to reply to an offer, includes additions, modifications, or limitations which do not materially affect the terms of the offer, is considered to be an acceptance unless the offerer objects thereto otherwise, orally or through a notification. Factors that can be materially affect the terms of an offer are listed under Article 19, subsection 3, and are the price, payment, quality, quantity of the good, place and time of delivery, extent of one party's liability to the other, or the settlement of disputes. To conclude, in order to validly form a contract under the CISG, there have to be two declarations of intent: acceptance and offer. The offerer should have a definite proposal in the intention to be bound by that proposal. The offeree, on the other hand, can accept the offer by a statement or through its conduct. Both Article 8 and 9 play an important role while interpreting an offer and acceptance. It should be emphasized that when formation is interpreted, the CISG should be considered as a whole. Thanks.
Thank you, Mr. Gaines. It's a very comprehensive overview of contract formation aspects when viewed from the provisions of the CISG. I would now invite Mr. Himesh Lal to take over the floor and.
Thank you. Thank you, Professor Pai. Just building on what Abhay said about applicable law when it comes to disputes and looking at the main problem or main issue when it comes to disputes, namely one of interpretation, I wanted to take a few minutes to look at Article 8 of the CISG to see how it actually works and how it can be a problem in international arbitration. Now, if we look at Article 8, I've highlighted certain words and added some additional words at the end of each subsection. But it's worth pausing just to look at each one. Article 8 is really dealing with how one interprets the dispute or the points in dispute as well as the various articles within the CISG. Subsection 1 is what we might call a subjective test. So it's all about interpretation, but it is all about what each party subjectively thought something within the CISG or in the other terms of the contract may mean. Article 8.2 is what we may call an objective test. It's not so much what the buyer or the seller thought something meant, but what a reasonable person standing back would think the words mean. Now, 8.1 and 8.2 are both about interpretation. But then we get to 8.3. And 8.3 is a really interesting subclause because it is saying, regardless of whether one uses 8.1 or 8.2, one is allowed to look at much, much more than just the written words or the objective index of information or factual background. It would allow the decision maker to look at evidence around negotiations, any practices which the parties had established between themselves after the contract had been executed and operated, usage, and other subsequent conduct of each of the parties. Now, this is the complete opposite to the parole evidence rule. But what is 8.3? Is it an aid to interpretation? Well, it says it is. But what is it in legal terms? Is it, in Abhay's example, part of the applicable law, so the substantive law of the contract governing the rights and obligations, or is it something more to do with evidence and procedure? Now, if we look at the next slide, we start to grapple with some of the potential difficulties. If we were to take Article 8 in its full form, there are 2 or 3 questions. Firstly, does it provide the law of the contract? If, assuming CISG is expressly identified to be the applicable law, and Article 8 in its unamended form is incorporated, does it provide the law of the contract? Or does it also provide the law of evidence, procedure? Now, this will depend upon the law of the seat. In some jurisdictions, 8.1 and 8.2 are, of course, substantive. They deal with rights and obligations. But what about 8.3? Is that, in some jurisdictions, all about evidence, or is it substantive? My own feeling is that 8.3 is really about evidence, because it is explaining to a decision maker what she or he can take into account when trying to assess what the parties mean by using certain words or what certain conduct may mean in terms of the written words. So I think it's about evidence and it's procedural. But if that's right, if Article 8.3 is about procedure, then it may cause problems in certain jurisdictions. So let's look at scenario 1. An arbitration tribunal applies 8.3 and it makes an award based upon the evidence that came to it through the prism of 8.3. So it's taken into account evidence of negotiations and perhaps material evidence of how the parties operated the contract in practice. But the award may conflict with the law of the seat. If, for example, there is some aspect of procedural law of the seat that does not allow the tribunal to take into account parole evidence. Now, one obvious example is in Singapore, where we have the Evidence Act 2012, which excludes the tribunal's rights to look behind what is written in the contract and go much further. What would that mean? There may be problems with enforcement. But the main issue that scenario 1 tells us is that if 8.3 is dealing with evidence and therefore procedure, it may cause problems at the supervisory court or at a court of enforcement if such national courts do not have the same approach to evidence as Article 12.3. It's a very simple point. The second scenario, the tribunal ignores 8.3 altogether, and it makes an award in the absence of any 8.3 evidence. And we assume that there was 8.3 evidence, but it chose to ignore it. It took the view that Article 8.3 was overreaching and conflicting with the laws of the seat, and therefore they expressly ignored it in the final award. One party argues that the tribunal is wrong. There's been either a procedural irregularity or an error in law, in the sense that Article 8.3 has not been correctly applied. Now let's imagine the National Court at the seat treats 8.3 as substantive, not procedural, as I would suggest, but as substantive, and finds that the material evidence that should have been looked at under Article 8.3 was overlooked, so that the award is not stable and could be set aside either on the basis of error of law or some sort of procedural irregularity. Now, what the scenarios are intended to signpost is that 8.3 is a very clear, easily understood article. We know what it allows the decision makers to take into account, but it could cause potentially fatal problems for the final award, depending on how the law of the seat treats evidence and how it construes Article 8.3. Whether it's procedural or substantive is one difficulty, and whether 8.3, if it is procedural, is held to conflict with the laws of evidence in the relevant seat. So one must always keep an eye on Article 8.3 and check, well, what does the law of my seat tell me about evidence? Now, this is not a purely academic issue. In a number of jurisdictions, there are cases that have looked at the difficulties that 8.3 can create. And I've just highlighted a fairly recent case from Singapore, BVU BVX 2019. Now, the facts are not so important. The real issue is whether Article 8.3 was sufficient to upset the final award. And put very simply, one party's submission was that Article 8.3 allowed extrinsic evidence that should have been given about the parties' negotiations of the contract. That evidence was not led in the arbitration and not called, and therefore there was a breach of Article 8.3, and therefore there was either an element of fraud or some element of procedural irregularity or error. So the real question was for the Singapore High Court, the real question was whether Article 8.3 applied and whether there'd been a failure to comply with 8.3. Now, you remember in my earlier slides, we highlighted that in Singapore, the Evidence Act 2012 does not sit well with Article 8.3. And that is what ultimately saved the final award in this case. The arbitrators had not followed 8.3. The High Court in Singapore decided that that was right. The arbitrators were correct not to follow Article 8.3 because it would conflict with the Evidence Act 2012. And therefore, although a key employee's evidence had not been given, that was not fatal, because in their view, it would have been an error to have allowed it in the first place. So therefore, the award was not set aside. That's a very short analysis of BVU and BVX, but I wanted to highlight how one tiny article in the CISG can have significant procedural difficulties in international arbitration. Professor Pai, that concludes what I wanted to say about Article 8.1. So I think I've given you back some time. Hello, Professor Pai, can you hear me? Or maybe we should hand over to the next speaker.
Good afternoon. Maybe I'll just wait 30 seconds to see if Professor Pai, or maybe Ria can confirm if it's okay to go ahead.
Yes. I'm just confirming with him. Just give me 30 seconds. I'll just confirm and I'll let you know. It's just here, right?
Okay, so yeah, I think Hamish has finished.
So your board sir has said that we can go ahead.
Yeah. So I think we discussed that the Q&A can be at the end of the session. So we can invite the next speaker now.
All right, sir. So we'll start with Mr. Akshay then. Sir, I'll just put on your presentation.
Thank you. I think I can start in the meantime. Good afternoon, everyone. Thank you very much, Professor Pai and Ria, both for your very kind introduction, and my co-panelists for the very insightful presentations. I will be picking up from where Hamish left. I will be talking about a particular provision of the CISG and how it has potentially created some difficulties, both procedural and substantive, in international arbitration and in international litigation. More specifically, I will be talking about the ideas of hardship, force majeure, of frustration in the context of the CISG. And thanks to the pandemic, there is a renewed and rather high degree of interest in these issues in recent times. And the concepts of hardship, force majeure, frustration, impossibility, each has a distinct legal meaning, and that meaning will often change depending on what legal system this concept is being invoked in. One thing, however, remains unchanged, that each of these concepts is actually trying to answer one common question. That is, when can some event result in a party being excused for its non-performance of the contract? Now, I use the phrase excused for its non-performance. It's a rather neutral wording. An English lawyer would have perhaps rephrased this question as, when can some event lead to the contract being discharged by frustration? As an Indian lawyer, I would rephrase it perhaps as, when can some event void the contract for impossibility? And you remember Section 56 of the Contract Act. So the key challenge when it comes to drafting a legal instrument like the CISG is what is called in comparative law as finding a neutral value. And this brings me more specifically to Article 79 of the CISG. And you'll see this article on the screen. And it's a fairly straightforward article at first. But there are numerous layers to this provision. And I'll try and unpack a couple of them in two broad points. First, you'll see that the word impediment is used. And a lot has been said about this word in legal scholarship. It has been called vague and imprecise. It has been called chameleon-like. It has been called ambiguous and contradictory. But all the criticism aside, the drafting history of this article actually tells us that this word impediment was the result of a very difficult compromise. Back in 1980, common law delegates were concerned about certain civil law jurisdictions' fault-based approach to contractual liability, and that should resonate with us. Once you have proven that there is non-performance, there is a breach, you shouldn't have to further prove that the other party was also at fault. And you have to understand that even in 1980, the drafters of the CISG, in respect of this particular idea, they had numerous options to come up with a legal concept. They had the option, the common law doctrine of frustration, impossibility. There was this Italian concept of excessively onerous performance. There was this French concept called en prévision. From international law, you have concepts like rebus sic stantibus, a fundamental change of circumstances. From German law, you have a concept which literally translates to frustration of commercial purpose of the contract. So in that sense, this word impediment in Article 79 of the CISG is somewhat of a novelty. But the compromise was not achieved through just picking this word alone. As you can see from this provision, the word impediment is actually heavily qualified. There needs to be an impediment beyond control, objectively unforeseeable, and one that cannot be reasonably avoided or overcome. But we can go on about the scope of this provision for a very long time, but I want to zoom in on my second broad point, which is about the idea of hardship. Now, as you see, the word hardship actually appears nowhere in Article 79. It actually appears nowhere in all of the CISG. This is quite unsurprising. We, even as Indian lawyers, do not see the word hardship in Section 56 of the Contract Act. And from what knowledge I have of English common law, in theory, hardship is not an accepted definition. So one might ask, why describe an event as hardship? Why not simply look at the underlying event in question and see if it qualifies as an impediment under the CISG or as an impossibility under the Contract Act? Remember, even under Indian law, impossibility is not literal or physical impossibility. It's something a bit more, as courts have clarified. The problem, however, with this thinking is that it ignores international sales law reality. There are many, many legal systems out there which separately define and accept the theory of hardship. And therein lies a problem. Hardship is actually a separate contractual concept. Consider a situation, let's take a hypothetical. An Indian party enters into an international sale of goods contract with a French party for the supply of goods. And in negotiations, you, as the Indian party, agree for French law to be applicable, knowing that it's eventually going to be the CISG. And let's assume that the arbitration is seated in Singapore. Of course, as a result of COVID, there are market fluctuations. The French party loses its suppliers, and the performance, even though it doesn't become impossible, it just becomes excessively onerous or very hard or very difficult. You, the Indian party, sues, and as a defense, the French party claims not impossibility, but rather hardship. And before I go any further in this example, it might be helpful to clarify what exactly hardship means. hardship, put simply, is more of an economic impediment. It more deals with the financial aspects of performance. And you can see the most modern definition of hardship is actually in a soft law instrument by the UNIDRAW, the Principles on International Commercial Contracts. And as you can see from the screen, the definition is a rather relaxed one. It deals with fundamentally altering the equilibrium of the contract because the cost of performance has massively increased, or because the value of the performance that you're receiving is diminishing. So this is the idea of hardship in general. Now let's get back to our Singapore arbitration example. The French party would not rely on impossibility, it would rely on hardship. And one interesting aspect of the CISG is something in Article 4. You'll remember from the first presentation, Mr. Gans spoke about how the CISG regulates formation of the contract. One thing that the CISG does not regulate is the validity of the contract or any of its provisions. And this is provided in Article 4. So a tribunal before which a party has raised the defense of hardship might very well assume that this is a question of validity of the contract and might come to the conclusion that you need to apply domestic law. And voila, you are applying Article 1195 of the French Civil Codes. So imagine a situation where you ended up with a contract negotiation applying for CISG, but you're arguing on French law. And by the way, the French law provision actually empowers the court or the tribunal to do something what common law lawyers might actually find outrageous. They could order a renegotiation of the contract. They could order for an adaptation of the contract, or they could actually declare a termination of the contract, even if such provisions are not originally negotiated in the contract. And the example I gave you is not exactly a hypothetical. It won't take you long to find a 2009 Belgium Supreme Court decision or a 1993 Italian court decision where the courts did precisely that. The Belgian case, for those of you interested, had a situation where the contract was for a sale and supply of steel tubes, and right after the conclusion of the contract, the price of steel rose by 70%. In many jurisdictions, and especially common law jurisdictions, this wouldn't be considered as frustration or even an excessively onerous performance. But the court in that case actually ordered the parties to renegotiate the contract, even though CISG was applicable in that case. So where do we stand with hardship and the CISG? In principle, even though in Article 79, there is no mention of the word hardship, there is a lot of support for the idea that hardship situations must be governed by the CISG. One may be uncomfortable with the idea that a court or tribunal is looking into the equilibrium of the contract and potentially rewriting the deal. But if there's something that last year has taught us, it's that equilibriums can indeed be radically altered and parties can indeed be put in excessively onerous situations where it might not be technically impossible to perform a contract. It might simply be unfair to expect a party to perform. So as a question, if you ask, can you invoke hardship in a CISG contract to justify non-performance? The issue, of course, is fact-specific, but there is no one clear answer, and there are a few solutions to this problem. One of my favorite solutions is to actually just look at Article 7.2 of the CISG. There is no need for any court or arbitral tribunal to actually rule that a hardship situation is not governed by the CISG. It is governed by the CISG, but in the event it's not settled, you can, using Article 7.2 of the CISG, look at the general principles on which this provision was based. And that's perhaps the best way to import principles like the UNIDRAW principles or lex mercatoria to apply to the contract and then just decide the dispute on the basis of the principles on which this provision is based. And then you might be able to argue that hardship is governed by the CISG. Similarly, another go-to provision of the CISG is Article 9(2), a sort of trade usage incorporation provision of the CISG, where a party can make similar arguments on the fact that if something is a matter common in international trade, you can always import it into your contract, and those will be considered as binding provisions. It's very similar to common law doctrines of implied terms, but there are some differences. I think that concludes, in substance, all that I wanted to say on this topic, and I would be very happy to pass the floor on to my colleague for his presentation, and happy to take any questions that you may have afterwards.
Thank you very much, Akshay. I'm sorry I couldn't, I had to re-log in because of some difficulty after the last session, after the last speaker. May I now call upon the next speaker? Animesh, Mr. Animesh?
Yes, thank you so much.
Thank you.
Thank you, National Law University, Delhi. Thank you, Center for Transnational Commercial Law. 2020 has been a year of reflection and review. And in sync with that, the topic of this conference is very relevant. And there is a need to review and reflect on what should be the way forward to stimulate trade and development post-pandemic. I would like to thank my co-panelists, Abhay, for giving a comprehensive review of formation of contracts under the CISG, Hamish for highlighting issues of interpretational challenges, and Akshay for dealing with this very relevant topic of our times on force majeure, frustration, and hardships. My presentation today is on access to commercial justice, specifically commercial justice, commercial courts. And I must begin by saying to get access to commercial justice is not the prerogative of courts alone. I will be making a case in my presentation that for an effective access to commercial justice, there has to be equal efforts put by the legislative bodies as well as the enforcement bodies. India has stayed away from CISG, considering it was one of the drafting members, and there was a heavy input by the Indian delegation on the formation of the CISG terms. And there has been an inconsistency in the fact that India as a country has accepted some other United Nations conventions. And why there is a difference, I think that is the question of my topic, and that is needs for access to commercial justice. Now, it's pretty self-explanatory why anybody would need access to commercial justice. And I will concentrate on speaking about the Indian jurisdiction here. But the need is not so simple. India is a growing economy. We are looking at more transnational business. We are getting into more and more bilateral investment treaties. And therefore, there is not only a case of investment and trade coming back into India, but now we are an aspirational country which is looking for investment and trade out of India. And therefore, it is very important to have a consistent access to commercial justice. It is very important to see the principles being discussed at this conference. And CISG brings with it a lot of experience in terms of substantive law, in terms of procedural law, in terms of how some of these challenges have panned out. Akshay mentioned in his presentation that where there are certain lacunae or points which are not explanatory, there are some available solutions within the convention itself. And I think there is a strong need for Indian courts and Indian jurisprudence to look within it. Now, what is the system of access to commercial justice in India? Apart from the constitutionally set up three-layered vertical of district courts, high courts, and Supreme Court, we in India have had several legislations setting up different specialized tribunals, whether they are in the area of environment or they are in the areas of consumer laws and dealing with commercial aspects of real estate and insurance. There have been aspects of debt recovery. And now in 2015, we've legislated a new law, which is the Commercial Courts, Commercial Division and Commercial Appellate Divisions Act 2015. The Act came into force on 23rd October 2015. So roughly we have 5 years of experience looking at this legislation. Along with the Commercial Courts Act, we have seen several changes to the Arbitration Act, where we have very happily looked at United Nations conventions to make our law and amend our law with the times. Given all of this structure and framework, what are the challenges that we are facing to access to commercial justice, especially in India? In my opinion, a primary challenge is that we are spread over different institutions. There are different tribunals which are dealing with different aspects. And while commercial courts are dealing with commercial disputes, and these disputes are very wide-ranging, dealing from carriage of goods to franchise agreements, technology development agreements, to dealing with import and export of merchandise, insurance and reinsurance. And therefore, they are not only dealing with trade intangibles, but they are dealing with trade in intangibles as well. But have we not created an extremely complicated and a confusing system where, as a person who is in the business, I am still unsure as to what is my means to access to justice? Do I go back to this set constitutional vertical of 3 courts? Am I supposed to go to different tribunals? Or should I now prefer to go to the commercial division courts? Also, there are many transactions which are so complicated that the entire dispute is spread over different transactions. And therefore, for a long time in India, the preferred mode has been to go for arbitrations, which has brought with it its own challenges. We have yet to be able to develop an international arbitration institution in the format of LCIA and SIAC, while there have been considerable discussion around it. Previous governments have shown their legislative will to create something like that. They have been very keen to bring policy on ease of doing business and have arbitration institutions of this nature. But we are yet to see any institution like this seeing the light of the day. I particularly remember attending a big jamboree which was organized when the Arbitration Act was amended. And a very important point was raised by a colleague from the Malaysian jurisdiction, and he said that, look, if in case there is very little judicial liberty on procedure and times, it may end up being a draconian system. And for example, if I'm dealing with very complicated construction contracts or contracts on energy, and if these arbitrations cannot be finished in a year's time, one may advise businesses to not invest in India simply because the law had a draconian 1-year effect. But that is extremely surprising because the cutoff period of 1 year was provided under the Arbitration Act to be able to stimulate business ease of doing business, but it could have a counteracting effect. And while I am not the expert to speak about business and how the law has impacted business, but in our day-to-day dealings, we have realized the challenges of dealing with complex commercial contracts. Another problem that we feel that we deal with India is infrastructure, arbitrations itself. It's not only a case of having an arbitration institution which is dealing with commercial disputes, but it is also important to have arbitration secretariats. Arbitrations itself require complex infrastructure where there has to be basic brick and mortar of having a proper room, a setup, an internet, proper recording of evidence, arbitrators traveling from different jurisdictions, experts who are going to give evidence in different areas. And this is not going to be possible until and unless we've got a separate system of arbitration secretariat. Another problem with arbitrations in India has been that it has largely been limited territorial limitations of the metropolitan cities, largely Delhi, Bombay, maybe Bangalore, Hyderabad, Ahmedabad. But if we are looking at a robust economy, if we are looking at different lines of business, if we are looking at stepping our foot into the manufacturing sector of the economy post-pandemic, it is critical that arbitration institutions, arbitration tribunals, arbitrators, the bar of arbitration must be spread across the country. And I have an interesting argument, which is not very interesting when you look at it transnationally. And that is that in India, we do not look at partnering of institutions like the Center for Commercial Law and other academic institutions into training of more arbitrations, into dealing with judicial consistency of decisions. India has been a developing country where there has been a lot of case-by-case approach to judicial decisions. we are still looking at some kind of consistency in judicial principles, which is where this conference is very relevant again. CISG is a lived document, and to keep away from such international instruments, we are only missing the bus in terms of getting some judicial consistency in dealing with commerce and businesses. Therefore, that is a critical challenge. It's not an easy resolution, but it is high time that we are dealing with training of judicial institutions, of judges, of arbitrators, such that there is consistency. Amish raised these very important aspects of interpretational challenges, and I think that's what we are facing with several commercial legislations. This is not only on the substance of the law, but also on the procedure of the law. The Commercial Courts Act itself is intended to make things simpler, but in practice, it has been very difficult for most practitioners. It is very format heavy, it is very bureaucratic, and sometimes just to get matters listed and filed becomes a pain. And this impedes access to justice. Also, we must have a review of systems of stamp duty and court fee filing. This is very prohibitive for small businesses, and that is what keeps us further and further away from judicial consistency in our affairs. Infrastructure itself of courts needs to be amended, and I think India has now reached a point where there must be considerable debate about efficacy of tribunals. We went on creating tribunals for two primary reasons: for expedition of matters and for resolution, which is nuanced, a more nuanced understanding of affairs. And a lot of the constitution of these tribunals are of people who are not just retired judges or judges, but they have to be experts of their respective field. While this sounds excellent on paper, and going forward in the post-pandemic world, it is going to be as important as ever, but in experience, that's not what we have seen. And today we are suffering with tribunals where there are lack of appointment of some of these judges and institutions. There is a very poor infrastructure in terms of expert evidence to be led in, and that is impeding access to commercial justice in India as well. The pandemic has showed us very interesting solutions, and digitization is one of which. It is an anathema that in a country where we are boasting of software technologies and we are boasting software services being exported to first world countries, we have done absolutely nothing vis-a-vis digitization of courts. And maybe it may be harsh to say that we've done nothing, for there has been a lot of governmental policy and push, but sadly it has just not been enough. We are still at very rudimentary system on service of pleadings, on completion of evidences. It is remarkable that even today in Indian courts, lawyers are appearing in matters and saying we have not been given a copy of the pleadings, where something can be emailed at the click of a button today, where service can be so easily effected on parties. Everybody has reached a stage where we in India are boasting of a massive network of mobile phone users. And in such a system, there is a critical need for digital innovation to provide access to justice. Access to commercial justice is not access to commercial justice to big corporations and big groups, because transnational trade, simple aspects of trade of simple goods, are not being done by big companies. They are being done by very localized vendors. A lot of them are small and medium enterprises, and they have taken a large hit because of the pandemic. It is extremely important to digitize our systems. Court dockets need to be digitized. Procedures need to be digital based. Services can be made online. Summons can be served online. And some of these processes can go a long way. I would like to conclude by emphasizing on evidence recording in India. And I think this has been a major challenge, whether we are dealing with tribunals, whether we are dealing with the regular vertical of the constitutional courts, whether we are dealing with the commercial division courts. We are severely lagging behind on recording of evidence. And this, again, is an area where we really don't need to create fresh systems. You simply need to look at models which are in countries not very far away. Singapore is a fantastic example of a country which has stimulated economic activity simply by way of ease of laws. We can also look at the West, where a lot of our legislation is being taken from England. There has been such a heavy review of these legislations, amendments, replacements, and strangely, we are still stuck with some of these legislations which are multi-decades old. And therefore, a very critical need is required for review of all of this, to see that evidence today is very varied. It's not on paper alone. There are evidence which can be in many different digital platforms. And it's a critical need to deal with some of these issues. I will conclude by saying two things. Expedition and nuanced delivery of decisions has been the framework of a lot of laws in India to provide access to justice. But unfortunately, that is exactly what we need today. Expedition of matters and more nuanced understanding. And sadly, whatever amendments we've done to the Arbitration Act, the changes we've made to banking transactions for debt recovery, for arbitral institutions, dealing with other transnational matters is sadly not enough. And therefore, if we are to keep pace with the promises that are being offered by the government, where there has to be a lot of stimulation of manufacturing in the economy and trade and investment and transnational work, the laws really need to catch up to be able to give access to commercial justice. Thank you.
Thank you, Mr. Sinha. It was a very wonderful presentation, all of you. I think the question by Mr. Sarthak Yadav is directed at Mr. Sinha. So the last speaker first. Sir, does a lack of technical expertise within judges also contribute to delay in commercial justice? Mr. Sinha.
I would say unabashedly yes. We've seen in the pandemic area where judges who have been quick to get on with digitization of the system, the courts are functioning remarkably seamlessly. Without taking names, there are some judges where by evening the orders are coming on our respective email IDs. And that's as quick as things can get. It's so simple. That can be done so easily. And then therefore, there are also judges who have never really had access to technology. And in many ways, they are just waiting for the physical system to resume. So I think that's a very bad way of thinking. And while I don't think we can completely digitize court system in India, but several small, regular, basic aspects can be digitized. Okay.
I think there are no further questions or somebody is typing. Until then, I think we can have a round of questions. So one of my first questions is to Mr. Gend from as a moderator. I've been tasked to conduct the session, and since I did not find any more questions, I think there is one more, sir, to follow up on the same. What can these students and professionals do to improve the state of commercial justice for MSMEs? I think Mr. Animesh, can you take it towards the end after the other questions? Yeah. So my question to Mr. Gain. So in situations where we have contracts that provide where there are beneficiaries, third-party beneficiaries, and I'm coming from the IP background here, wherein we have international contracts between standard-setting organizations and patent holders, wherein third parties are located in jurisdictions like India, China, etc. And these third parties are never party to these contracts. So in such a situation, how does contract formation work? And this has been one question that has never been answered very systematically because the courts have usually referred to the jurisdiction of standard-setting organizations based on French law. But within the framework of CISG, and if CISG would operate, how would such contract formation take place where the third-party beneficiaries are not present in the formation of the contract, but are final beneficiaries in different jurisdictions? If that is a relevant question for you. Mr. Gaind? Mr. Abhay Gain, can you hear me? I don't think I can hear Mr. Gain. Okay, then Ria, can you hear Mr. Gain?
No, sir, I can't hear him.
Okay, then we'll wait for Mr. Gain to respond later.
Yes, I think he's here.
Hi, Oliver. Can I call you back in this number in about 6 or 7 minutes? Yeah. I'm just on a video call. I'm just finishing up. And no worries. 6-7 minutes. Don't worry. Good man. Bye-bye.
Then the question to Mr. Lal. To what extent would Article 8 cover current industry practices that are specifically not looked into within the subjective aspects of a contract? For example, again coming from in the intellectual property background, we have contracts where licensing methods and royalty structuring are not specifically laid down in those contracts, but there have been prevailing industry practices for 20 years, 30 years in specific industries. So to what extent could Article 8, particularly Article 8 Clause 3, could consider industry practices? So that's the question. Yeah.
Thank you. I think two things. First of all, Professor Pai, it is possible that what you're describing could fall within 8.2, because it could be part of the background information that an objective observer should take into account. So that's the first point, that if the issue or industry practice is so widespread, it should be within the head of the objective observer. That's number one. But second, if it's not, and you want to rely on 8.3, then my only point is that, yes, CISG 8.3 allows you to run the argument, but one needs to be very careful that when you run the argument, you're not going to hit problems when you come to enforce the award. So it's almost like you've got to look, as a contract lawyer, you've got to look at your argument and look at the argument you want to make based upon 8.3, then check what the law of the seat says in terms of evidence to make sure that there is no clash. And then if there is a clash, make sure that the issue is properly addressed in the arbitration terms of reference so that the arbitrators do not accidentally make an error. But I think it's a combination of 8.2 and possibly 8.3. It's a very clever question you raise because it's very fact sensitive.
It's very fact sensitive, and we see this because there has been huge divide within industry on some aspects of royalty structuring, wherein the historical practice today is being denied, and other kinds of practices that are slowly evolving are being substituted as some kind of industry practice, or at least that's the argument that academics have tried and made. I don't know how successfully, and that's the context of what I asked. But thank you very much for that answer.
You're welcome.
And going back to Mr. Gain, if you can quickly answer the question that has been raised in the chat box. This is with reference to major investment project, that if profitability anticipated does not meet to its expectation against the investment and financial model shows it to be not economical, can one party fail to meet its financial obligation on the ground of hardship? I think the hardship question was specifically I think it should have been directed to Mr. Sridhar, but nevertheless, Mr. Sridhar, you want to go ahead, and then we can call in Mr. Gain also. Mr. Sridhar.
Sure. Thank you, Professor Pai. Yes, so the question first is, can you even, I'm assuming that this is a contract where the CISG applies. So the first question is even, can you raise a defense of hardship? And one very key issue here is that it needs to be read in context of Article 79 of the CISG, and the threshold is really high. And again, this is a very fact-sensitive question, but if we are to see that the profitability of the initial investment model does not correspond with the profitability of the later investment model, I think the question is more of assumption of risk, and that is something that is inherent in Article 79. It is for the party that is producing the financial model to have assumed the risk of the accuracy or inaccuracy of its model. So it cannot afterwards come back and say that this is something that is now leading to hardship, and therefore it must be excused from non-performance, because one key condition in Article 79 of the CISG, as it is in many other legal systems, is that it should have been not reasonably foreseeable at the time of the conclusion of the contract. So if there is a study and if it has been reasonably foreseeable at the time of the study, you cannot come back and claim a defense for hardship or for impediment. But again, this would be a very fact-sensitive analysis. And I appreciate that this question could go either way depending on how the court or tribunal feels.
Wonderful. Thank you. Thank you, Mr. Sridhar. Mr. Gain, can we have you back? Mr. Gain? I don't think we can hear. Ria, can you hear Mr. Gain?
No, sir, he's not audible. Even though his mic has been unmuted, he's not audible.
Yeah, he's not audible. Okay, no, not an issue. Then I think we can straight on move to Mr. Sinha and continue with that follow-up question he had on access to commercial justice for MSMEs.
The idea is to innovate, and India is in dire need of innovation, not only in terms of product, but also in terms of analysis. And how you can innovate as a student and as a professional is to look at these issues, write, author as much as you can. Several times government opens consultancy papers to comment, and I think it has become a very non-participative model where comments aren't really coming from a lot of practitioners. And I think here students and academics can really step in, write to the government, give a more nuanced view, because a lot of the amendments, if you examine them carefully, really are knee-jerk solutions. And that's not the way if you're looking at judicial consistency, and that's really not the way for MSMEs, because judicial consistency is critical to get access to commercial justice to MSMEs. So good question, innovate, write, participate in consultancy papers. I think that will be very useful.
Wonderful. So if there are no further questions, I will call an end to this panel, and it was a very successful panel indeed. We had 4 fantastic speakers who had different perspectives that were laid out on the question of CISG, and of course on the domestic question of access to commercial justice in India. I thank you, Professor Garg and National Law University Delhi, all the joint organizers of the event, and thank each one of you, the speakers and the audience, for having been part of this wonderful session. Thank you. Over to you, Ria. Thank you very much.
Thank you so much, sir. Thank you to all the panelists who could join us today and all the participants who joined us for the session. We'd now break for lunch, and the session number 3 would start at 3 p.m. So I look forward to all the participants